940. And appearance, counsel?
Good afternoon, Your Honor. My client we can send a mapping soon.
Please stand up for the record.
Jesse Taylor.
You say Justin or Jesse?
Jesse, sorry.
Okay. All right. And counsel, as to the arraignment.
We waived formal reading. My client stands mute.
Schedule this matter for pretrial on May 16th at 10:30 a.m. And counsel, as to bond.
Your Honor, my client indicates that he will appear at any and all future court dates. I believe that there was a little bit of a misunderstanding regarding fingerprints, but he will be cooperative going forward. He is gainfully employed. He moves furniture. He is living with his father in Lincoln Park. He does have one child. In fact, he was looking forward to seeing his son today. Judge, we're respectfully requesting any leniency this honorable court could consider. Thank you, Judge.
All right, thank you. And Sergeant Fitzpatrick, did you want to address bond? And if you do, please state your name for the record.
At this point, the defense attorney tries to present the defendant in the best possible light, mentioning his job, his living situation, and the fact that he has a child. These details are often brought up in court to convince the judge that the defendant is stable and likely to return for future court dates.
Yes, I do. Sergeant Robert Fitzpatrick.
All right, thank you. And as to bond.
Your Honor, he was given at least five opportunities to provide his fingerprints starting from last night to today. The response that he gave when we tried to get him this morning, I'm not going to repeat in open court. His criminal history is extensive. He has multiple arrests for assaultive behavior, resisting instructing police before, failed to provide DNA and fingerprints in the past also. He currently has a warrant for his arrest already, $15,000 cash warrant out of
But the prosecution quickly pushes back. According to the sergeant, the defendant has an extensive criminal history, including prior arrests for assault and resisting police. Even more concerning to the court is the claim that he refused to provide fingerprints multiple times.
28 districts. For those reasons, I think a $10,000 10% bond would be appropriate in this matter.
I'm sorry, you said 10,000, 10%?
Correct, ma'am.
Okay. Okay, Mr. Taylor. You've been making a pretty big ruckus back there because you've interrupted my record a few times today with how loud you've been in the back.
I didn't think he could hear me.
Sir, what I heard was not questions, they were just yelling. And where do you work, sir?
I work for a company called Courtroom. I move furniture.
And how long have you worked there, sir?
This will be my 6th summer.
Your 6th summer. What do you do when it's not summer?
It gets slow, so I mean, I'm on call, but I build racks and find odd jobs and just stay next to the phone.
All right, how old is your child?
He's 6.
And do you have a parenting time agreement?
Yes. Today's supposed to be my day. Every
What's that?
Wednesday, every other weekend.
Every Wednesday and every other weekend?
Yes.
All right. And okay, well, I'm going to have you sign in place of right form. Were you given one to fill out, sir?
I believe so.
Did you fill it out?
No, not completely yet, but I will.
Did you fill any of it out, sir?
No, I was reading over for a split second. I was just handed handed it.
When were you handed that document?
When I stood up in front of, well, before I see my lawyer, I was handed the document. I haven't got the time, I didn't get the chance to read it all the way through yet.
Okay. And what's your warrant for 28th District Court? What's that for?
I'm supposed to serve the rest of my 30 days, but I wanted to have the money first. And work's been slow. We just started picking back up. I want to go in there with a handful of cash and make it right with the court and not go in there empty-handed. And that was my fault.
Well, sir, if you're going to serve the rest of your 30-day jail sentence, then you don't really need the money at that particular moment, I don't think.
Well, I don't
And then
know.
is that for assault? Is that, I'm sorry?
I apologize.
No,
Well,
go
Judge,
ahead.
Judge, I did go through my client's constitutional rights. I went through them step by step, so he understood all of the rights he had today.
Okay. And thank you. And so, Mr. Taylor, your, what is it the warrant's for? Assault battery?
I think it's just a simple assault.
Okay. And if you were to test today, sir, what would be detected in your system?
I think I'd be all right. I don't smoke weed or anything.
Okay, would anything be detected in your system?
Dan, oh, sorry. What's that? You're on it again.
Would anything be detected in your system?
No.
Okay. Based upon the fact that there's a warrant out for defendant's arrest, the behavior while he's been in custody, the court's going to, from the nature of his charges and the criminal history, the court's going to indicate $10,000, 10% bond. Not without consuming alcohol or drugs unless prescribed. One of your bond conditions, sir, is you have to submit to fingerprints.
Yes, ma'am.
And I will be very clear with you, sir, if you do not submit to those fingerprints, immediately upon being done here on the record, I will call you back up.
After hearing both sides, the judge makes a decision. The court sets a $10,000 bond with 10% required, meaning the defendant would need to pay $1,000 to be released. The judge also makes it clear, if he refuses to cooperate with fingerprinting again, he could face additional charges for contempt of court.
On the record, you will be held in contempt of court. Is that clear?
Yes, ma'am. Now, with the 10% of 10, what is that, 1,000?
Yeah.
I don't have that money, Your Honor, and I have to get my car. I'm gonna have to work with Southgate too, probably. Please.
No, sir,
I mean,
based upon what the court's been told on the record, the information the court has in the file, no, this is your bond.
okay.
Thank you, Judge.